Hey there, I'm the MadCatster. Am I glad to see you here? Well, we've got developments in the Jeanette Braun and Lauren the Mortician lawsuit against Jessie Smiles and some other creators. They've all filed motions to dismiss the lawsuit. So we're going to go over them and take a look at what they've got to say. You know me, I've got the deets and all the receipts, so buckle up and let's go. So I'm here with Cedric the Bold today. Bold because he goes everywhere fearlessly and gets in the way of everything. He's a sweet boy, though. Sybil's upstairs. I'm assuming she's going to make her way down here at some point because she can hear me, I'm sure. And usually that's enough to get her to get out of bed and come down. But she's fine. Thank you so much, you guys. All the people who have expressed support for Stefan and for all the people who had donated towards his medical bills. I will give you an update on Stefan in my next video. I don't want to be distracted today. I've had a lot on my mind. It was a tough week. So please hit like and subscribe, you guys. We're just about to hit 45,000 subscribers. We're 5,000 away from the 50. I know a lot of you who are watching are not subscribed. Please like and subscribe. We would really, really appreciate it. I've got a bunch of people to thank at the end of the video for all the generous things that have come from the Amazon wish list and some people that bought me coffees. Let's talk about Jeanette Braun, aka Janet, and Lauren the Mortician, and the ongoing hot mess of a lawsuit that they've got going on in federal court in Illinois. And I've got 3 motions to dismiss that were filed by all of the parties involved. They're all represented by the same attorney, which is great. So in the first motion to dismiss that I'm going to go over, I will read like the background a little bit, but I won't do that in the other 2 motions because it's duplicative and it's not necessary because it's the same attorney and basically the same verbiage. So let's take a look. So you'll see here we've got Jeanette Braun, Braun IP Law, and Lauren Propson, who's Lauren the Mortician, against Rebekah Day, owner and operator of the online social media account Caffinatedkitti, Lily Marston, Jessica Vasquez. And it's Rebekah Day's memorandum of points and authorities in support of her motion to dismiss. So let's take a look at what she has to say. And here's the introductions. Plaintiff Jeanette Braun and Braun IP Law, collectively Braun, or we'll call her Janet, because we know how much she loves that, filed this complaint against defendant Rebekah Day in an improper effort to silence Day and other unrelated individuals who have independently voiced opinions about Braun on social media that she deems unflattering. Braun contends that Day has defamed her through posts and or stories that Day has posted on her personal account on the social media platform TikTok, in which Day has referred to Braun as unethical and rogue and expressed her subjective belief in italics, because that's what it is, it's her opinion, that Braun has filed false copyright strikes under the Digital Millennium Copyright Act on behalf of her clients, including her co-plaintiff Lauren Propson. But as explained in detail below, Illinois law is clear, because that's where the suit was brought. It was brought in the federal court in Illinois. Illinois law is clear. Whether someone is unethical or rogue is so ambiguous and indefinite that it cannot be verified. Thus, such hyperbole is deemed to be a constitutionally protected opinion and not actionable as defamation. The fact that these statements were made in the context of stories or comments Day posted on her personal TikTok account only underscores that they amount to nothing more than Day's unfiltered subjective beliefs. That's what commentary is all about, people. The same can be said for allegations that Braun filed false copyright strikes. How would one go about verifying whether a lawsuit or other proceeding is false? As explained herein, Day believes the defamation claims asserted against her in this action are false. Does she open herself up to further defamation claims by expressing that opinion? Certainly not, given that none of the statements on which Braun bases her defamation claim are actionable. Braun has failed to state a claim for defamation. Not only are the alleged defamatory statements on which this action is based non-actionable opinions, but they are subject to a qualified privilege under Illinois law, which requires that Braun plead facts supporting claims of actual malice. As Braun has alleged nothing more than boilerplate conclusory allegations regarding Day's alleged malice, and we talked about this like with the Illuminati thing, the lack of specifics. It's like all of these vague statements and conclusions, legal conclusions, that are not backed up by any specifics or any details. As Braun has alleged nothing more than boilerplate conclusory allegations regarding Day's alleged malice, Braun has failed to overcome the qualified privilege. Accordingly, Day respectfully requests that this court dismiss Braun's defamation claim along with the remaining defectively pled tort claims based on non-actionable defamatory statements under Federal Rule of Civil Procedure 12b-6. And that's what we commonly call 12b-6 motion to dismiss, means a failure to state a claim for which the court can grant relief. It's basically what it is. So in this one, the first one, Bekah Day's motion, I'm going to read the background and I'll read some other stuff that I will not read in the other two to try to keep this as short as possible. Believe me, I don't want it to be any longer than it has to be either. And I will only in the other two read like the specific allegations against those parties. We already know that defamation, what defamation is, what they're saying, that, you know, these are all opinions, and that's pretty much a common theme. There is one difference between the other two motions and this particular motion. In the other two motions, they assert defenses of anti-slap. And I'm sure you've probably heard that term bandied about. We've talked about it just briefly on here, but I'm going to talk about it in the Jessie Smiles motion, which is next. My guess is that I think it's Missouri law probably does not have, I'm not shocked, anti-slap legislation on the books to protect free speech. So we'll go over anti-slap in the next one. But here's the background, and again, I'm only going to read this one time. Plaintiff Lauren Propson is a social media personality, and plaintiff Jeanette Braun, through plaintiff Braun IP Law LLC, collectively Braun, is her lawyer. Propson is a licensed mortician residing in Wisconsin who operates a social media account on TikTok under the name Lauren the Mortician. Propson alleges that she has amassed millions of followers on TikTok, as well as sponsorships and monetization of the videos she posts of TikTok, including brand partnership with a famous documentary channel. And that's something they're quoting from the complaint, where this vague allegation of some brand deal that went bad allegedly because of what these women said. And we get no specifics, like what channel are you talking about? What was the deal? How much was it worth? We don't get any of that. Propson alleges that her lighthearted and educational videos posted on TikTok discuss death, the loss of loved ones, and demystify occupations and professions that work with deceased persons. Propson hired Braun, a lawyer, to assist with her copyright infringement claims by filing a Digital Millennium Copyright Act complaint to social media platforms, hosting a video created by one of the defendants, who the complainant names as KC, the owner and operator of the social media account Caffinatedkitti, hereinafter referred to as KC. The complaint alleges that Casey is a social media personality and is a citizen and resident of Georgia. Propson and Braun have asserted individual defamation and other tort claims against Casey in this action based on statements allegedly made by Casey on social media about Propson and after the filing of the DMCA copyright strike against her about Braun. So what they're talking about, and I'm sure a lot of you know, Janet filed a whole bunch of copyright claims with YouTube and with TikTok and other places, trying to get videos that had any kind of negative comments about her or Lauren the Mortician taken down because they didn't like the opinions that those people held. Under the doctrine of fair use, the people who she targeted did not violate the Copyright Act, and actually YouTube even told Janet that no, we're not going to take the videos down because there's no violation. So Janet probably had a temper tantrum because YouTube wouldn't bend to her will, and she sent a threatening letter or email or something to YouTube. Anyways, it's fair use. In addition to asserting defamation and other tort claims against KC, plaintiffs have also named other defendants based on alleged defamatory statements these individuals purportedly made on social media, including Day. The complaint alleges that Day is a social media content creator known as Bekah Day, who holds herself out to be an unbiased content creator and an independent investigative reporter. The complaint alleges that Day is a citizen and resident of the state of Missouri. The complaint further alleges that in November 2023, defendant Day made content regarding defendant Casey's claims about Ms. Propson and attorney Braun, on which plaintiffs based their claims. Now we go into what the alleged defamatory statements are. They allegedly created and posted videos stating the false claim that attorney Braun files false copyright strikes is unethical and is a rogue attorney. In support of this allegation, the complaint sets forth a screenshot of a reply to a comment allegedly posted by Day stating, I posted proof on my page that your legal name is attached to the false copyright strikes. Don't know why you're behaving like this on the internet. The complaint does not identify to whom the comment is directed when the comment allegedly was posted or where on the internet the comment allegedly was posted. So again, lack of specifics. The complaint also sets forth a screenshot of what appears to be a social media post by Day, in which Day states, there are a group of creators on this app who have weaponized Jeanette's aggressive, threatening, and unethical tactics to scare creators off the app. I have a list of creators who have utilized Jeanette and another list of creators who have been wrongfully impacted by false copyright strikes sent in by Jeanette. Shocked and applauded to see women in mutuals with hiring this woman to do their dirty work. 'Tis the season of exposing, I suppose. The complaint does not allege where on the internet the statements were posted or when the statements were posted. The complaint further alleges that in a since deleted video from TikTok, Day stated the following. But I just want to make it very clear that my position is to ensure that there is not a rogue attorney on this app. Finally, the complaint alleges that Day posted a story on TikTok stating that the Illinois Attorney Registration and Disciplinary Commission told her, Day, they received multiple credible complaints about Jeanette Braun and they have assigned multiple attorneys to investigate the matter. The complaint contains no allegation that this statement is false. In other words, they're saying that's defamatory, but they're not saying that the statement is false. So that's kind of interesting because usually you're going to say that it's not true and it's defamatory. In this case, they're just saying it's defamatory. So what does that mean? Is it true? We'll find out, I guess. Rather, it states that upon information and belief, the ARDC does not comment or provide input on the merits of an investigation to anyone calling to inquire about a registered attorney. So that's also interesting. Again, what they're saying is that the commission that investigates claims of misconduct doesn't release any details about their investigation. So again, they're not denying that this is true. Upon information and belief, the disciplinary commission would only confirm whether or not the attorney in question was registered, convey the date they were registered, share if the attorney is in good standing, and share if the attorney has ever been found to have engaged in misconduct. The complaint is devoid of any allegation that Day made false or defamatory statements about plaintiff props. So they're saying that they're not alleging that Bekah Day said anything defamatory about Lauren the Mortician, just against Janet. And so I'm not going to go through the whole argument, but basically what they're saying is under 12b-6, a defendant may move to dismiss for failure to state a claim upon which relief can be granted. In determining whether a complaint satisfies Rule 12b-6, the court accepts the facts stated in the complaint as true and draws reasonable inferences in plaintiff's favor. Now, we talked about this in some other lawsuits too. So in other words, the court figures, well, as the complaint and the litigation progresses, there'll be discovery, there'll be evidence that'll be brought forth to support the claims made in the complaint. And so the court's not going to determine whether or not there's any merit at this very beginning stage. And I think it was Sniper Wolf, we talked about this same thing. Usually they will let a complaint move forward unless it's completely obvious that there absolutely is no merit to it. And then the court may dismiss it. Though a complaint need not contain detailed factual allegations, a formulaic recitation of the elements of a cause of action will not do. So you can't just say, she said something bad, she published it to other people, therefore it's defamation. You have to give some detail. You don't have to give all the detail. You've got to make it clear what exactly it is you're claiming was defamatory. Rather, the complaint must contain enough facts to state a claim to relief that is plausible on its face. A complaint fails to state a claim where the well-pleaded facts do not permit the court to infer more than the mere possibility of misconduct. Here, as explained below, plaintiffs have failed to state facts sufficient to constitute any cause of action against Day. The court can look at it and say, there's nothing in this complaint that looks meritorious and that's going to hold up to scrutiny, and therefore, why waste the litigation process? Let's get rid of it now and not continue through this process. The complaint does not state a claim for defamation against Day. To state a claim for defamation under Illinois law, a plaintiff must plead facts showing the defendant made a false statement concerning the plaintiff. And these elements of what defamation is, it's pretty consistent, worded maybe a little differently, but the premise is pretty much consistent through. Now, in terms of laws about defamation, in most states, although the language may be a little bit different, it's pretty much the same concept. So the elements that I'm going to read you are pretty consistent, and there's a pretty fairly consistent view of what defamation is. And it says, under Illinois law, a plaintiff must plead facts showing the defendant made a false statement concerning the plaintiff. There was an unprivileged publication of the defamatory statement to a third party by the defendant, and publication of the defamatory statement damaged the plaintiff. Count 3 of the complaint asserts a claim for defamation per se by Braun against Day, based on Day's alleged statements that Braun was unethical and that she files false copyright lawsuits without proper investigation, and that Day used her platform to attack Braun's character and reputation. The complaint does not include any claim for defamation asserted by Propson against Day. Braun fails to state a claim for defamation against Day for a variety of reasons. Number 1, Day's alleged false copyright lawsuits, unethical, and rogue statements are non-actionable opinions. The complaint alleges that Day defamed Braun by publicly stating that Braun files false copyright lawsuits and is unethical. However, such statements are non-actionable as they constitute constitutionally protected opinions rather than verifiable statements of fact. A statement is constitutionally protected opinion if it cannot reasonably be interpreted as stating actual facts about the plaintiff when viewed from the perspective of an ordinary reader. Only statements capable of being proven true or false are actionable, opinions are not. And they go on to explain what the difference is. To determine whether a statement is factual in nature, Illinois courts consider whether the statement has a precise and readily understood meaning, whether the statement is verifiable, and whether the statement's literary or social context signals that it has factual content. If it is clear that the speaker is expressing a subjective view or interpretation, such as when the speaker discloses the facts forming the basis for the statement is not actionable as defamation. Here, Day is expressing her subjective opinion that the copyright claims filed by Braun lacked substantive merit. And it's just her opinion. Janet cannot like it, but it's not defamatory. If I say I think you're a horrible person, that's not defamation. That's my opinion of you. So it's not true or false, right? It's subjective. Moreover, the term false is not verifiable because it has no precise and readily understood meaning. What does it mean for a DMCA copyright claim or strike to be false? That it lacks merit? And by whose standard? Does it mean that there are substantive defenses that the content creator at whom the strike is directed can assert, or that the claim was filed for an improper motive? The term false is so broad in scope that it lacks the necessary detail to have a precise and readily understood meaning required to be actionable. So basically what they're saying is, it's a subjective opinion. There's nothing there that you can say, well, that's true or false. And I'm not going to go through the rest of this here, but you get the gist of it. So they're basically saying these were all opinions. They're not defamatory, and therefore there is no claim here. Now I'm going to skip here to number 2. Day's alleged false copyright lawsuits and unethical statements are subject to a qualified privilege. So this is their second defense of why they're saying that these statements are not defamatory, because they're subject to qualified privilege, and you'll see what that means in a second. Allegations that Braun is unethical or files false copyright claims are subject to a qualified privilege under Illinois law. Such a privilege may exist where the situation involves an interest of the person who publishes the defamatory statement or an interest of the person to whom the matter is published. Courts also recognize as privileged communications involving a recognized public interest. Whether a qualified privilege exists is a question of law for the court. Day's statements are privileged because they relate to her interest in protecting her freedom of speech in her social media posts and in not being subject to DMCA copyright strikes filed by Braun in response to statements made on social media with which Braun's clients disagree. Moreover, the statements made by Day were published to those who share that interest, i.e., other individuals who have social media accounts who have been or could be subject to DMCA copyright strikes filed by Braun. Thus, under Illinois law, these statements are subject to qualified privilege. Basically, what they're saying is that Bekah Day made these statements because of her own personal interests. So these copyright strikes were filed against her, so she's expressed an opinion that they're false because she's the one being subjected to them. Therefore, it's qualified privilege because she's entitled to express her opinion about something that's happening to her. Or also what they're saying is to other people who this particular situation could directly impact as well. Once qualified immunity has been identified, a plaintiff may overcome this challenge at the pleading stage by alleging the statement was made with actual malice, either knowledge of its falsity or in reckless disregard of the truth. Courts in this district, however, have looked for something more than conclusory statements in order to infer that the defendant knew statements were untrue or recklessly disregarded the truth or falsity of these statements. Here, the complaint contains nothing more than a conclusory statement that Day's defamatory statements were made with knowledge of their falsity and with reckless disregard for the truth. There are no facts alleged to support this boilerplate allegation, and without such facts, Braun cannot overcome application of the qualified privilege. So it's true, and we've talked about this in other lawsuits. You can't just say, well, she made statements I don't like, and she did it on purpose, and she knew they were false. Well, so you need to provide facts to support that assertion. You can't just say broadly, oh, well, she knew they were false, and she did it anyways. You've got to show why you believe that she knew they were false. How do you know what she knows? You're not inside her head. And then we'll go to number 3. Day's alleged statement regarding information from the Illinois ARDC is not actionable. So the Attorney Registration and Disciplinary Commission. The complaint alleges that Day posted a TikTok story in which she stated that the Illinois Attorney Registration and Disciplinary Commission told Day they received multiple credible complaints about Braun, and they've assigned multiple attorneys to investigate the matter. It's unclear whether Braun's defamation claim is based on this allegation, as Count 3 refers only to the unethical and false copyright claim allegations. Regardless, such a claim is not actionable. First, there is no allegation that the statement is false. Janet's just mad because that statement went out to the viewers. She's not saying, well, you're lying. She's just saying, I don't like you talking about me like that. So, that's not defamation. It has to be a false statement. If you're not saying it's false, then should we infer that it's true? A false statement is an essential element of a defamation claim. Hello, yes. Nowhere in the complaint does Braun allege that the ARDC did not tell Day that it had received multiple credible complaints about Braun and is investigating the matter, or that the ARDC did not actually receive multiple credible complaints. Without such an allegation, Braun cannot state a claim for defamation. Now, I'm wondering if this is going to cause Janet to file a motion to amend the complaint so that she can go in now and say it's false. I don't know. We'll have to wait and see. Second, a republisher, as Day is here, they're saying, well, she's just a republisher, that she didn't come up with that information. She got it from somebody else. Here, Day is merely republishing statements allegedly made to her by the ARDC. Thus, Braun must allege facts establishing actual malice. The complaint is devoid of any factual allegations to support its conclusory statements of knowledge of falsity or reckless disregard for the truth. Its bare-bones boilerplate allegations are insufficient. Third, the statement is subject to an innocent construction. The innocent construction rule requires the court to adopt an innocent construction of allegedly defamatory statements if such an interpretation is reasonable. A statement that the ARDC is investigating Braun does not, in and of itself, indicate that Braun has committed professional misconduct, which is true. Just because they're investigating doesn't mean she did something wrong. Because if somebody complains, they investigate. That's just the way the process works. 9 out of 10 times it may turn out that there's nothing there. Somebody was just trying to cause trouble or was being bitchy about something. Given that this statement is subject to an innocent construction, Braun cannot state a claim for defamation based on it. C. The complaint does not state a claim for false light or trade libel against Day. Because Braun has failed to state a claim for defamation against Day, its false light and trade libel claims against Day arising out of the same allegations of defamation must fail as well. The complaint does not state a claim for tortious interference against Day. Braun has asserted a claim for tortious interference with existing and potential business relationships against all defendants, including Day, based on allegations that Day's defamatory statements have caused and are likely to continue to cause the public and content creators not to employ Braun for legal representation. Under Illinois law, a claim for tortious interference with prospective economic advantage requires that plaintiffs show 1. Their reasonable expectation of entering into a valid business relationship, 2. Defendants' knowledge of that expectancy, 3. Purposeful interference by the defendants preventing that expectancy from being fulfilled, and 4. Damages resulting from such interference. The plaintiff has to have an actual intention of entering into a deal with another party, but you have to show that the defendant knows that that potential deal is going on, the defendant then has to do something to sabotage that arrangement or that deal or partnership, and that the plaintiff has to actually be damaged. So in other words, if they were going to get $50,000 from this contract with XYZ company, and Mr. Jones comes along and says, I don't like the fact that you're trying to do business with them, I'm going to poison the deal and tell XYZ company that you're a horrible person, so they will not do business with you. Therefore, the deal will get canceled. Now, then that would be tortious interference. Here they're saying that doesn't exist. And they go on to say, Braun fails to allege any facts regarding the existing or prospective relationships with which Day interfered. So again, lack of specificity. You can't just say, oh, well, she ruined my chances of doing business. Well, where? Who? With whom? What was the deal? When was it supposed to happen? How much were you supposed to get? And how much did you get damaged by losing that deal? Here, Jeanette is just making this vague statement and broad statement without any facts to show that there actually was tortious interference. The complaint does not state a claim for intentional infliction of emotional distress, and we've talked about this with so many lawsuits. Intentional infliction of emotional distress is one of the hardest things to prove in a trial. I would say maybe 90% of the time it fails because the bar is so high to show intentional infliction of emotional distress that very few cases meet the requirements to pass muster, and they get thrown out. Those counts get dismissed. Curiously, Popson, Lauren the Mortician, has asserted a claim for intentional infliction of emotional distress against Day based entirely on Day's alleged defamatory statements about Popson. However, Popson did not assert a defamation claim against Day, and the complaint is devoid of any allegations of defamatory statements made by Day about Popson. Whether this claim was simply a typographical error or an effort by plaintiffs to see what sticks, so in other words, they're trying to be polite here and dance around the fact that they just think that they're making unsupported claims to just see what will pass muster and what the court will allow to stay. Popson's IIED claim against Day based on non-existent defamatory statements fails and must be dismissed. For the foregoing reasons, Day respectfully requests that this court dismiss counts 3, 7, 11, 14, and 16, which are the counts against Day herself, because all of the defendants are part of this one lawsuit, and these claims just related to Bekah Day, so those are the ones she's asking to be dismissed. She can't ask for the whole thing to be dismissed because she doesn't have standing to argue on behalf of the other defendants. They have to file their own motions, which of course they did. Now, the next motion to dismiss is Lily Marston and Jessica Vasquez, aka Jessie Smiles. They were named together because the alleged defamatory statements come from their podcast, Do We Know Them? So they are basically co-defendants on the counts related to them. I'm going to read the introduction, but I won't read the background again because we already went over it. Defendants Lily Marston and Jessica Vasquez are the third set of social media content creators who have been targeted in this action by plaintiff Jeanette Braun, Braun IP Law, collectively Braun, who allegedly is a social media lawyer. I love the way they threw in allegedly there. That's kind of a little... For the sole reason that Braun does not like what these two individuals have said about her practice online. As alleged in the complaint, Marston and Vasquez co-host an online podcast called Do We Know Them, in which they allegedly promote online controversies, rumors, and celebrity gossip. That's what it said in the complaint. One such controversy, rumor, and gossip discussed by Marston and Vasquez was Braun's harassing and intimidating litigation tactics on behalf of her social media clients, including plaintiff Lauren the Mortician, which Marston and Vasquez believed to be unethical. Ironically, in response to Marston and Vasquez voicing their constitutionally protected opinions regarding Braun's unethical tactics, Braun has now utilized that very tactic on them. Pretty ironic. Namely, Braun is attempting to silence their honest but unflattering opinions through this patently defective action, in which Braun asserts defamation and a myriad of other tort claims meant to intimidate Marston and Vasquez. While it appears that Braun has made a career out of silencing social media content creators, she cannot be permitted to do so in this case. Not only is Braun's claim for defamation legally insufficient, but it is based on a textbook example of a protected activity under applicable anti-SLAPP statutes. Now here's where the slap comes in. And it's also going to be cited in the last motion because the states that these parties are from have anti-slap provisions. And anti-slap, I'm not going to go through a detailed definition, but what slap is strategic lawsuits against public participation. And basically, in a nutshell, what it means is a person or an entity doesn't like what you're saying. They want to shut you up because even though what you're saying may not be defamatory, they just don't like it. It's negative publicity. And in order to shut you up, they sue you. And they're hoping to financially cripple you so that you will capitulate and do whatever they want, whether it's issue an apology, retract a statement, whatever, in order to settle this litigation. Well, thankfully, many states have realized that, well, this is not right. You can't just sue someone because you don't like what they say to shut them up. That's a violation of free speech. You may not like it, but if it's not defamatory, oh well, it's a free country for the time being. Under anti-slap statutes, they're saying that this lawsuit is textbook slap and it should be thrown out because it's just meant to shut them up. Under applicable anti-slap statutes, statutes which were enacted for the very purpose of preventing this type of lawsuit, brought primarily to chill the valid exercise of the constitutional rights of freedom of speech. All four causes of action asserted by Braun against Marston and Vasquez should be stricken under the applicable anti-slap statutes and or dismissed under Federal Rule 12b-6, and Marston and Vasquez should be awarded their attorney's fees. And because slap lawsuits are usually vindictive in nature, the statutes allow for the defendants to recoup their attorney's fees that they had to expend to defend this frivolous lawsuit from the plaintiff as punishment for the plaintiff bringing a frivolous lawsuit. Now, the next part is the background, which we don't need to go over again. We're just going to jump right to Marston and Vasquez's alleged defamatory statements. Per the complaint, in November 2023, Defendant Vasquez and Defendant Marston began posting several videos discussing the dispute between Defendant Casey and the plaintiffs, in which defendants expressed a strong contempt for plaintiffs, and they're entitled to that, intentionally mispronounced Braun's name, calling her Janet, published statements about Braun's clients and her legal practice. The complaint further alleges that without discussing the full context of any specific post or takedown, Defendant Marston stated that attorney Braun's practices were unethical. Well, there's no law requiring that if you express an opinion, you have to give all of the context and related purported facts in order to show how you formed your opinion. That's not how it works. Set forth below this allegation is a screenshot in the complaint they're talking about. There was a screenshot from what appears to be episode 97 of Marston's and Vasquez's podcast titled Lauren the Mortician's Lawyer is Way Worse Than We Thought, and Vlog Squad Where They Are Now, with the subtitle stating as follows: about a creator she basically goes to allegedly unethical lengths to. I'm not quite understanding that, but the screenshot indicates that the episode has, at the time of the screenshot, received 5,500 likes, and that the podcast has, at the time of the screenshot, 97,600 subscribers. The complaint alleges that in the same episode, Vasquez also states that Braun is unethical and sets forth the screenshot from the same episode with the following subtitle: is that as unhinged as Janet is, as unethical as Janet is she? Again, these fragments of sentences I'm not really understanding. The complaint further alleges that Marston continued to make false accusations and accused attorney Braun of unethical behavior on various platforms without identifying the specific accusations or platforms on which they were allegedly made. Finally, the complaint alleges that in a since-removed post, Marston made further false accusations and referenced Braun through a past client and accused her of actively committing perjury. I'll give you the context. I believe what that was referring to, the perjury, was that when you file a copyright claim with YouTube and probably other social media as well, you have to give a sworn statement that what you're alleging is true under penalties of perjury. Okay? So what they were saying, what Lily Marston was saying, is because YouTube said there was no merit to the copyright claims. The fact that Jeanette Braun stated that the facts were true under the penalty of perjury, that she perjured herself. Below this allegation is a screenshot of what appears to be a 12/10/23 Twitter post by Marston stating, "I gotta say, one of our biggest questions in all of this is, do we think Demps knows that her embarrassing excuse for lawyer is using her name while actively committing perjury? Someone might want to tell her." And so that's what that was referring to. They go on to say, the claim, and I will read just a little bit of this, that California and Georgia anti-SLAPP statutes apply in this case, and that's why that the claim should be stricken. In the case of an anti-SLAPP statute raises a defense to a defamation claim, the choice of law question regarding the anti-SLAPP law is treated separately from whether a statement is defamatory, because the anti-SLAPP question involves whether a statement is privileged, not whether the content is defamatory. Pursuant to de passage, the court can apply different states' laws to different elements of the lawsuit. Although the place of the alleged injury might be critical in determining the law applicable to the defamation claim, the choice of law for anti-SLAPP protection involves protecting the speaker's exercise of First Amendment rights and could lead to the application of different state law. Namely, in determining which law to apply to defenses raised pursuant to anti-SLAPP statutes, courts have found the place where the allegedly tortious speech took place in the domicile of the speaker central to the choice of law analysis. Here, Marston and Vasquez are citizens and residents of California and Georgia, respectively, and there is no allegation that the alleged defamatory speech originated anywhere other than California and Georgia. Thus, California and Georgia have a strong interest in protecting Marston's and Vasquez's speech, respectively, and their anti-SLAPP laws apply to Braun's claims. Number 2, Marston and Vasquez's statements constitute a protected activity under Georgia and California anti-SLAPP statutes. As a preliminary matter, the Georgia anti-SLAPP statute and the California anti-SLAPP statute are virtually identical. And, it's pretty consistent from state to state where there are anti-SLAPP laws that it's pretty much similar type language, such that Georgia courts look to California case law interpreting the California anti-SLAPP statute for guidance. And that's what we, in legal terms, what we call persuasive authority, meaning the decision in the court is not from a court that directly impacts a particular court. So in other words, if I'm in Georgia and I'm in the Superior Court, a decision from the Georgia Supreme Court or an appeals court is going to directly impact the lower court. And so that's what we call precedent. Persuasive authority is when there is another state whose courts don't directly impact the court in question, where a decision was made that we say it's analogous to the situation. So because the laws are similar, what they're saying is it's of interest to see how the California courts interpret certain things because the language of their statutes is so similar, and it may have some influence over the way the Georgia court is going to rule. But it doesn't mean that they have to rule that way, because California doesn't have any jurisdiction over the Georgia court. It says that the analysis of an anti-SLAPP motion to strike involves 2 steps. First, the court must decide whether the party filing the anti-SLAPP motion has made a threshold showing that the challenge claim is one arising from protected activity, free speech. If so, the court must then decide whether the plaintiff has established that there is a probability that the plaintiff will prevail on the claim. Second step in an anti-SLAPP analysis is to consider whether the plaintiff has demonstrated a probability of prevailing on the claim. A protected activity is conduct which could reasonably be construed as an act in furtherance of the person's or entity's right of petition or free speech under the Constitution of the United States or the Constitution of the State of Georgia or California, in connection with an issue of public interest or concern or a public issue. Protected activities under both the Georgia and California anti-SLAPP statutes include any written or oral statement or writing or petition made in connection with an issue under consideration or review by a legislative, executive, or judicial body, or any other official proceeding authorized by law. Any written or oral statement or writing or petition made in a place open to the public or a public forum in connection with an issue of public interest and concern. And any other conduct in furtherance of the exercise of the constitutional right of petition or free speech in connection with a public issue or an issue of public concern. The statute is intended to protect persons exercising their constitutional rights of petition and freedom of speech. To accomplish this goal, the statute is to be construed broadly. So they're citing to a case here, and they're saying that it states that It shall be construed broadly, and the California Supreme Court has interpreted the anti-SLAPP statute broadly, cautioning that a narrow construction would serve Californians poorly. There can be no question that Braun's claims here are based on statements made by both individuals in a public forum, meaning online on their podcast, which is accessible by the general public for free, in connection with a public issue or an issue of public concern. The complaint alleges that the statements were published on the internet in connection with a podcast that has at least 97,600 subscribers, and the video itself received at least 5,500 likes. The complaint also alleges that Marston made an additional alleged defamatory statement on Twitter. Social media and online platforms are considered public forums under both Georgia and California anti-SLAPP statutes. Let's skip down here. It says, to determine whether an issue is an issue of public concern, so we've established that it was a public forum. Now we have to determine whether the issue is of public concern. To determine whether an issue is an issue of public concern, under the Georgia anti-SLAPP statute, courts consider whether the subject of the speech or activity was a person or entity in the public eye or could affect large numbers of people beyond the direct participants, and whether the activity occurred in the context of an ongoing controversy, dispute, or discussion, or affected a community in a manner similar to that of a governmental entity. Courts also broadly construe the phrase issue of public interest when applying the California anti-SLAPP statute. An issue of public interest is any issue in which the public is interested. Well, makes sense, right? In other words, the issue need not be significant to be protected. In other words, it doesn't have to be legislation, or it doesn't have to be some national significance. It can be something that affects just like a specific group of people. It is enough that it is one in which the public takes an interest. Courts look to whether the subject of the speech or activity was a person or entity in the public eye, or could affect large numbers of people beyond direct participants. Marston's and Vasquez statements on their podcast, as well as Marston's statements on Twitter, constitute a matter of public interest or concern, and thus qualify as protected activities under both the Georgia and California anti-SLAPP statutes. This is not a matter that affects only Marston, Vasquez, and Braun. Rather, they were communicating to their over 97,600 subscribers about Braun's litigation tactics on behalf of her social media clients and their impressions of Braun based on her conduct, namely, their belief that Braun's practices are unethical. When the alleged defamatory statements are viewed in the context in which they were made in the video referenced in the complaint, as opposed to merely the screenshots included in the complaint, it is apparent that Marston and Vasquez are alerting their viewers to their belief that Braun is utilizing unethical litigation tactics and trying to intimidate social media content creators who post content that Braun's clients find unflattering. Indeed, with respect to the screenshot in paragraph 89 of the complaint, the allegedly defamatory statements made by Marston and or Vasquez in context are as follows. And that's the common thread. Braun takes down things that are either embarrassing to a creator or negative about a creator. Basically, she goes to allegedly unethical lengths to silence people's critics or bullies, as she says, but come on. Likewise, with respect to the screenshot at paragraph 91 of the complaint, the allegedly defamatory statements made by Marston and or Vasquez in context are as follows. Okay, so that's the common thread, we believe, is that Bunny XO, longtime client, has been referring this girl to everybody, meaning Jeanette. And all of the sudden, Janet is way too many people's lawyer, as I said. The crazy part is that as unhinged as Janet is and as unethical as Janet is, she's finding some success in her practices. Whether short-term or not, but she's kind of low-key slaying, but in the worst way. They go on to discuss how it seems like Braun was successfully silencing content creators and no one was coming forward until now. So they're saying that, she was getting away with it because people weren't fighting back, even though the copyright claims they believe were bogus. They were basically just letting the videos get taken down. They go on to discuss how it seems like Braun successfully silencing content creators and no one was coming forward until now. And it's just like there's no shortage of people Braun is harassed with legalese and a bunch of gibberish. Most people don't understand and they'll just be like, I'm going to jail. Because Jeanette not only threatening legal action, but she references the potential penalties if her baloney claims are actually correct, in my opinion, to try to intimidate and scare people. Oh my God, I could go to jail for this. Marston's Twitter post alleged in paragraph 93 of the complaint similarly relates to a statement regarding unethical tactics engaged in by Braun on behalf of one of her social media clients referred to as Demps. Under both Georgia and California law, a statement that Braun is engaging in unethical or harassing conduct is unquestionably a matter of public concern affecting a large group of individuals, i.e., social media content creators who might be targeted by Braun or who might be considering using Braun as a lawyer. Marston and Vasquez's warnings to content creators about Braun's conduct in episode 97 is a protected activity under the anti-SLAPP statutes, regardless of whether the warning was sincere, accurate, or truthful. Number 3, there is no probability that Braun can prevail on her claims. Once a defendant has established that their claims asserted against it arise out of protected activity, as Marston and Vasquez have done here, the burden then shifts to the plaintiff to demonstrate that there is a probability that the plaintiff will prevail on his or her claims. In federal district court, an anti-SLAPP motion may be premised on legal deficiencies inherent in the plaintiff's claims, analogous to a motion to dismiss under 12b-6. So a motion to dismiss for anti-SLAPP, they're saying, basically, in the federal court, has the same effect as a 12b-6 motion for failure to state a claim. And if a defendant makes a special motion to strike based on alleged deficiencies in the plaintiff's complaint, the motion must be treated in the same manner as a motion under 12b-6, except that the attorney's fee provision of the anti-SLAPP statute applies. So the court basically looks as it would under 12b-6 of whether there's any merit. However, because the anti-SLAPP statutes provide for attorney's fees because it's considered frivolous, basically, and trying to be punitive and going after the defendants unfairly, they're entitled to the attorney's fees they had to expend to fight this in court. And that the federal court will adopt that provision, giving attorney's fees if the defendants win. So, and then they just reiterate here that, though a complaint need not contain detailed factual allegations, a formulaic recitation of elements of a cause of action will not do. Rather, the complaint must contain enough facts to state a claim to relief that is plausible on its face. Here, Braun has failed to state facts sufficient to constitute any cause of action against Marston and Vasquez. Thus, each of the claims should be stricken and attorney's fees should be awarded to Marston and Vasquez under the Georgia and California anti-SLAPP statutes. Then they move on to the defamation claim. And they reiterate that under Illinois law, the plaintiff must show that the defendant made a false statement, that there was an unprivileged publication of the statement to a third party, and the publication of the defamatory statement damaged the plaintiff. And we've talked about this before. You can't just sue someone for defamation because you don't like what they said. Even if they defamed you, you have to have suffered damage. In order to be awarded financial damages, something negative has had to happen to you. You can't just say, they defamed me. You've got to show how it actually hurt you. And if you can't, then your complaint's not going to survive, because without damages, there's no relief the court can give you as a plaintiff, because the whole point of these lawsuits is to get money. That's what it boils down to. And if you didn't suffer any monetary loss or damage that the court can compensate you for, then there's no point in you bringing a defamation lawsuit. Here, count 4 of the complaint alleges that Marston and Vasquez defamed Braun by publicly stating that she's unethical and commits perjury and using their platform to attack Braun's character and reputation. The allegation that Marston and Vasquez defamed Braun by stating that Braun is unethical cannot state a claim for defamation under Illinois law, as such a statement constitutes a non-actionable opinion protected under the First Amendment. And I'm not going to go over this because it's basically sort of similar to what they've said. So basically they're saying that it's opinion. It's not defamatory. You cannot defame someone by expressing your opinion of them. So they're basically saying the complaint is defective because these allegations of defamation just don't hold up when you're considered that what was said was an opinion. Equally defective is Braun's allegations that Marston defamed Braun by stating in a Twitter post she commits perjury. The Twitter post does not identify any particular statement made by Braun that Marston contends constitutes perjury. Essentially, this statement is nothing more than Marston calling Braun a liar without any factual context. Illinois law is clear that a general statement that someone is a liar, not being put in context of specific facts, is merely opinion. So again, there's no specifics there. You can't just say, oh, she called me a liar and I didn't like it. You've got to have some specific, well, what did she say you lied about, in order to determine whether it could possibly be defamation. Moreover, under Illinois law, social contexts are a major determinant of whether an ordinary reader would view an alleged defamatory statement as constituting fact or opinion. Thus, where potentially defamatory statements are published in a setting in which the audience may anticipate efforts by the parties to persuade others to their position by use of epithets, fiery rhetoric, or hyperbole, language which generally might be considered as statements of fact may well assume the character of statements of opinion. So, that's a good example. This is a podcast. There are so many controversial podcasts out there where the things that are said are people's opinions, and that they may be offensive or they may be hyperbole, but, it's an opinion. And people expect a podcast to contain opinion, is what they're saying. So they're saying the audience would not necessarily have interpreted a statement that she's a liar as being a fact, but rather they would recognize it as an opinion. Not only are Marston's and Vasquez's statements about Braun non-actionable opinions, but they are also subject to qualified privilege under Illinois law. We talked about this earlier. A privilege may exist where the situation involves an interest of the person who publishes the defamatory statement or an interest of the person to whom the matter is published. Courts also recognize as privileged communications involving a recognized public interest. Whether a qualified privilege exists is a question of law for the court. Marston's and Vasquez's statements are privileged because they relate to their own and their viewers' interest in protecting their freedom of speech as social media content creators and not being subject to intimidating litigation tactics by Braun on behalf of her clients, as well as the public interest in protective free speech on social media. And, again, it's the same, that just by alleging this statement was made with actual malice, either knowledge of its falsity or reckless disregard for the truth, must do so with more than conclusory statements. And we talked about that earlier. Braun cannot prevail on her false light and trade libel claims. It's basically similar to the last one and the tortious interference as well. And then they, again, alternatively, Braun's claims should be dismissed under Rule 12b-6. As explained above, Braun is not likely to prevail on any of the 4 causes of action asserted against Marston and Vasquez because they are legally insufficient, i.e. they fail to state a claim under 12b-6. If the court determines that Marston's and Vasquez's conduct is not a protected activity under applicable anti-SLAPP statutes, Marston and Vasquez respectfully request that the court dismiss the claims under 12b-6. So they're saying if the court doesn't think it falls under SLAPP, then they should dismiss it because it doesn't state a claim for which the court can grant any relief. For the foregoing reasons, Marston and Vasquez respectfully request that the court strike counts 9, 8, 12, and 14 of the complaint and award them the attorney's fees they have incurred in connection with this motion, or alternatively, dismiss the claims for failure to state a claim under 12b-6. And then we go on to the last of the 3 motions. And this is Defendant Casey, the owner and operator of the social media account Caffinatedkitti. It's her memorandum points at authorities in support of her special motion to strike pursuant to anti-SLAPP, or in the alternative, motion to dismiss pursuant to Rule 12b-6. And then I'll read the introduction, but again, this part's we're going to skip because it's the same as the other 2. Essentially, at its core, this action is an attempt by an alleged, well-known social media influencer with millions of followers and her lawyer to silence an individual who has voiced opinions about them on social media with which they disagree. While plaintiff Lauren Probson and her lawyer Jeanette Braun, Braun IP Law, Caffinatedkitti Braun, may not like what defendant Casey, the owner and operator of Caffinatedkitti, hereafter Casey, has to say about them on TikTok, the allegations of the complaint reveal that Casey's alleged statements are nothing more than her opinion, her subjective beliefs, and at worst, hyperbolic name-calling. They are not actionable as defamation is a matter of law. Not one of the alleged defamatory statements is a verifiable statement of fact. Not only do these statements not constitute defamation under the applicable substantive state law, but importantly, they fall within the scope of protected activity under Georgia anti-SLAPP statute, which governs Georgia speakers such as Casey, who the complaint alleges is resident of Georgia. Put simply, this case is nothing more than a joint and inappropriate attempt by a lawyer and her client to bully and intimidate an individual for speaking her mind and exercising her First Amendment rights. Indeed, the complaint itself reveals the lengths to which plaintiffs will go to harass Casey for voicing her opinion, namely calling the police in Georgia and sending them to conduct a wholly fabricated wellness check on Casey. And I talked about that in one of my earlier videos. Because plaintiff's allegation of defamation are based on statements that are protected activity under Georgia anti-SLAPP law and are legally deficient and non-actionable, the Georgia anti-SLAPP statute mandates that all 9 causes of action asserted by plaintiff against KC, all of which arise out of the alleged defamatory statements, be stricken and attorney's fees awarded to KC. Alternatively, and like Jessie Smiles, Casey respectfully requests the court dismiss all 9 causes of action asserted against her for failure to state a claim under Federal Rule 12b-6. Given that, as explained below, all of the claims rely on alleged defamatory statements that simply are not actionable under applicable law. Alternatively, at a minimum, Propson's claims against Casey, which are curiously joined with Braun's claims, and we talked about that, how it's weird that the attorney and the client are both plaintiffs in a lawsuit against these defendants. It's just really weird. Alternatively, at minimum, Propson's claims against Casey, which are curiously joined with Braun, should be dismissed under Federal Rule 12b-3 for improper venue because Propson is a Wisconsin resident, Casey is a Georgia resident, and this venue has no nexus to, involvement with, or interest in the adjudication of Propson's claims. So basically they're saying that the issues that the defamation claims concern are between Lauren the Mortician and KC. And because neither of them lives in Illinois, the Illinois federal court shouldn't be hearing this part of this lawsuit. And I thought it was really weird that they threw them all as defendants together. The whole lawsuit is really weird. Realistically, Jeanette and Lauren should each have filed their own lawsuits. And you would expect, because these defendants all made different statements at different times and in different ways, that they would be 3 separate complaints. And we'll skip the case background because we've already know what it is. And now we skip to defendant KC's allegedly defamatory statements regarding Propson. Propson alleges that on or around October 24th, 2023, Casey published a video on TikTok and identified her by her public persona, Lauren the Mortician. The complaint contends that in the 10/24/23 TikTok post, Casey accused Propson of being transphobic and of TERF because she liked posts by a social media personality who was in a same-sex relationship. The complaint that TERF is a derogatory slur, highly offensive term, an acronym standing for, and I'm not going to read this out, which is a term used to refer to or describe an advocate of this type of feminism who does not believe that trans people's identities are legitimate and who is hostile to the inclusion of trans women in the feminist movement. The complaint then sets forth screenshots from the TikTok post in which plaintiffs allege that defendant Casey accuses Ms. Propson of being a TERF and transphobic. One of the screenshots depicts Casey with the text of Lauren the Mortician is a TERF. The other screenshot depicts a picture of Casey with the text unfriendly reminder. We see this phobia, so we're saying they're phobic. That ain't bullying. It's an astute observation. Boondocks 2014. And bi people can be phobic. So, because Lauren the Mortician, I guess, allegedly claims that she's bi. Neither of the screenshots depict any text stating that Propson is phobic. Propson alleges that in explaining her reasons for her accusations, defendant Casey stated that she was not accusing Ms. Propson of being phobic because Ms. Propson has a larger fan base and following, but because people were confusing Ms. Propson's Lauren the Mortician persona with defendant Casey's Caffinatedkitti persona. Now, that's weird. That's the first time I heard that. The complaint further alleges that in the 10/24/23 TikTok post, Casey also announced that she compiled a list of links to posts that Ms. Propson liked that contain phobic or hateful rhetoric. The complaint depicts another screenshot of the 10/24/23 TikTok post that depicts a picture of Casey over a background of a social media account profile for an individual named Anthony Raimondi under the profile Conservative Ant, which indicates that Lauren the Mortician follows the conservative account. The screenshot further depicts a comment from Casey stating, "I'm not one for drama, but when I'm getting confused for someone, it becomes my business. And I value being thorough when it comes to addressing any accusation against someone else. Is it too much to ask that people hate me for who I am?" I guess, and not for what Lauren the Mortician is. Anyway, take my information and do your own research if you like, but refusing to address why hateful content is so likable smells like cowardice to me. I'll post my link in the comments for y'all, but do not comment on this guy's derogatory stuff. It is rage bait for a reason. The complaint alleges that, upon information and belief, none of the videos defendant Casey linked contained phobic and hateful rhetoric. Upon information and belief, Casey's motives and intent were to tarnish and damage Ms. Propson's reputation. When viewed in its entirety, it is apparent that the statements made by Casey in the 10/24/23 TikTok post are limited to statements by Casey that Propson actively follows and likes social media posts that contain phobic and hateful rhetoric. And because Casey finds such rhetoric offensive, she does not want people on social media to confuse her for Propson or her Lauren the Mortician persona. I wouldn't either. Nowhere in that TikTok post does Casey state that Propson or Lauren the Mortician is phobic or has made specific phobic statements herself, rather only that she has liked posts by other individuals who have made these statements. Nowhere in the complaint do plaintiffs allege that Propson has not liked these posts, interesting again, or followed these individuals on social media. Moreover, nowhere in the complaint do plaintiffs allege any facts demonstrating that any statements made by Casey in the TikTok post are false. You know, again, we were talking about that. I mean, you have to make a false statement for it to be defamatory. Defendant Casey's alleged defamatory statements regarding Braun. As stated above, Propson hired Braun to file a DMCA copyright complaint with Meta regarding Casey's alleged use of Propson's copyrighted material in a post on Facebook, not TikTok, which Meta approved. The complaint alleges that Casey then used her social media account to express her anger and resentment of Braun. Isn't that what social media is all about? Specifically, plaintiffs allege that on November 21st, 2023, Casey posted a video accusing Propson of using Braun to file bad faith copyright claims with social media platforms. And in the same video, Casey accused Braun of filing bad faith copyright strikes against Casey. Plaintiffs allege that Casey posted the same video again on TikTok on November 25th, 2023. Both TikTok posts are collectively referred to as the 1123 TikTok posts. Contrary to the allegation in the complaint, nowhere in the TikTok post does Casey state that Braun filed a bad faith or false copyright claim or strike against Casey. To the contrary, Casey does not even discuss the copyright strike for most of the video. Rather, Casey describes how Braun called the police and sent them to Casey's home in Georgia to conduct a wellness check, as well as how Braun sent Casey a cease and desist letter on which Braun copied Casey's mother in a theater company with which Casey is not even affiliated. That's really weird. It's like, you don't send a cease and desist letter to somebody's relative or parent, you know, unless, of course, they're a minor, or to a place where they thought that maybe Casey worked. That's malicious, okay? That is purposely weaponizing this process to try to smear or damage Casey. The letter should have just gone to Casey. That's the way it works. Plaintiffs further allege that on November 21st, 2023, Casey created a page on the donation platform called GoFundMe and posted on this page a portion of a cease and desist letter that Casey received from Braun. There's nothing wrong with that. It's a letter sent to her. It's not confidential. The complaint alleges that on December 8th, 2023, Casey published on the GoFundMe page her email response to Braun, again, not confidential, and falsely claiming that Braun filed a false copyright claim and that she was a fan of Lauren the Mortician and was not actually retained to be Ms. Propson's attorney. So they're basically saying she's not really representing her, she's a friend, and she's just doing this as a friend, sort of. The complaint sets forth a screenshot of the GoFundMe page, again irrelevant, that reflects Casey's email response to Braun regarding allegations of copyright infringement. It states in relevant part that Casey would love further details on Braun's clients and how the video had grounds for a copyright strike, as it clearly falls under fair use. I do understand how you have reached out with cease and desist to smaller content creators speaking negatively about Lauren the Mortician scandals, and while I understand your desire to protect a creator you enjoy, if you are not legally obtained, or retained should be, as counsel for her, and I speak on this via my platform, your allegations are going to cause her significantly more strife. So they're saying if pretending to be her attorney, if you're not actually been hired to represent her, it's just going to cause more problems. Plaintiff's complaint should be stricken under anti-SLAPP, and we talked about this in the last one in Jessie Smiles, that, you know, basically they're saying that the lawsuit's frivolous, the claims are frivolous, it's only being done to try to damage financially Casey and the others, and to cause them to have to fight this lawsuit in court, and hopefully get them to capitulate in order to stop it and enforce a settlement, but that it's really bogus, and therefore the anti-SLAPP statutes should kick in here, and, you know, these claims should be stricken by the court. And same thing, you know, that once Casey's established that the claims asserted against her arise out of protected activity, then the burden shifts to the plaintiff, demonstrate that there's a probability that they'll prevail. And Braun cannot prevail on her defamation claim. To state a claim for defamation, a plaintiff must plead facts showing defendant made a false statement. There was an unprivileged publication of the statement to a third party, and publication of the defamatory statement caused damage. They say here the complaint alleges that Casey defamed Braun by publicly stating that Ms. Braun filed false copyright lawsuits, and by implying that she was acting as an attorney without being hired by Lauren the Mortician. And Why she thinks that, I'm not quite sure. I didn't really follow that whole discussion. And she used her platform to attack Braun's character and reputation. The complaint also alleges that Casey stated that Braun filed bad faith copyright strikes against her. And based on YouTube's response, I would agree. And that Braun was accused of being an unethical lawyer that files frivolous copyright claims. Well, if the shoe fits. As a preliminary matter, the allegation that Casey defamed Braun by using her platform to attack Braun's character and reputation does not state a claim for defamation under Illinois law. Defamation per se must be pled with a heightened level of precision and particularity. This higher standard is premised upon an important policy consideration, namely that a properly pled defamation per se claim relieves the plaintiff of proving actual damages. Then they cite a case here and says, holding that plaintiffs do not identify any particular statement that forms the basis for this allegation. This imprecision leaves defendants and the court guessing as to which statements are at issue. And we talked about this in the whole Illuminati Oz Media lawsuit, where, you know, there's all this vagary. It's like, well, you got to tell me exactly what you're talking about and what you think is defamatory. You can't just say they made statements. Thus, the vague allegation that Casey attacked Braun's character and reputation without precise identification of the actual words used cannot state a claim for defamation. As for the allegation that Casey defamed Braun by stating that she files false copyright lawsuits or bad faith copyright strikes or claims, they also are patently defective. As a preliminary matter, both the 1123 TikTok posts and the GoFundMe website referenced in the complaint make clear that Casey is of the opinion that Braun had no grounds to file a copyright strike against her. And so apparently she said of the opinion, and I say that a lot too, in my opinion. People say, why do you always say in my opinion? Because it's my opinion. I don't want you to get confused and think it's actually some black and white fact. I'm giving you my opinion. Rather, the only reference to the copyright strikes filed against Casey by Braun in the TikTok is Casey's statement that she found the copyright strike to be bizarre. Likewise, the screenshots of the GoFundMe page posted by Casey reveals a letter from Casey to Braun with the subject line false copyright claim. It states only that Casey and her team would love further details on your client and how the video had grounds for a copyright strike, as it clearly falls under fair use. A party who has been sued or otherwise had a legal proceeding instituted against him or her is certainly permitted to express their disagreement with the merits of the proceeding without being liable for defaming the opposing counsel, as such a statement is a non-actionable opinion. It's true. I mean, if Janet's accusing you of a copyright infraction, you certainly have the right to defend yourself and say to her, I think you're full of shit, and your copyright claim is meritless and bogus, and whatever else your opinion of the situation might be. A statement is constitutionally protected opinion if it cannot reasonably be interpreted as stating actual facts about the plaintiff when viewed from the perspective of an ordinary reader. The court considers whether the statement has a precise and readily understood meaning, whether the statement is verifiable, and whether the statement's literary or social context signals that it has factual content. If it's clear that the speaker is expressing a subjective view or interpretation, such as when the speaker discloses the facts forming the basis for the statement is not actionable as defamation. Here it's clear that Casey is expressing her subjective opinion that the copyright claim had no grounds, based on her opinion that defense of fair use is applicable. Furthermore, use of a term false or even bad faith, assuming Casey even used that phrase, has no precise and readily understood meaning. The phrase deeply greedy people has no precise meaning, is not verifiable. Further, the context in which the phrase appeared indicates that it may have been judgmental, but it was not factual. This statement is not actionable. The terms false and bad faith are so broad in scope that they lack the necessary detail to have a precise and readily understood meaning, which are required to be actionable. And we'll skip down here. Finally, Braun's allegation that Casey defamed her by implying that she was acting as an attorney without being hired by Lauren the Mortician is also non-actionable opinion. Both the transcript of the TikTok post and the GoFundMe page make clear that Casey thought that Probson might not have hired Braun as her attorney. So she's not saying, I know she's not her attorney. She's saying she thinks she's not her attorney. She's entitled to say that. Okay, so, I'm going to skip through the rest of this. Talk about, the qualified privilege issue again, and that privilege would apply in this situation. And B, Probson cannot prevail on her defamation claim. The complaint alleges that Casey defamed Probson by publicly stating in the TikTok post that she was a TERF and phobic, and used her platform to attack Probson's character and reputation. The complaint alleges that the false statements were defamation per se because the harmed plaintiff's reputation is obvious and apparent on its face. Being called phobic is akin to being called, the B word or the R word. Because the complaint alleges that Probson is a citizen resident of Wisconsin, Wisconsin law governs the substantive issues. As explained above, in connection with Braun's defamation claim, allegations that Casey defamed Probson by using her platform to attack Probson's character and reputation fail because Probson has failed to identify any particular statement that forms the basis for this allegation. This imprecision leaves Casey and the court guessing as to which statements are at issue and accordingly failed to plead facts to support the claim with adequate specificity. And again, the lack of specificity in some of these lawsuits. And, generally speaking, defamation must be based on statements of fact rather than expressions of opinion. Statements of opinion are not defamatory. And so I'm going to skip the rest of this because, clearly the gist of it is they're saying these were all opinions in each of these cases. They're either opinions and not actionable or they're covered by qualified privilege. And so there are no defamatory statements to support the claims made by the plaintiffs in this, in my opinion, frivolous lawsuit. And they, again, about the false light and trade and about the tortious interference, it's all pretty much the same. Infliction of emotional distress, like I went over in the Jessie Smiles one. And again, the alternative, if the court doesn't strike the claims under anti-SLAPP, then they're asking the court to dismiss the claims under Rule 12b-6 for failing to state a claim for which the court can grant relief. And in conclusion, for the foregoing reason, Casey respectfully requests the court strike counts 1, 2, 5, 6, 9, 10, 13, 14, and 15 asserted by Probson and or Braun against Casey under the anti-SLAPP statute, award attorney's fees she's incurred in connection with this motion, or alternatively, because this is really all the work that's been done so far, and this is these motions, and we've talked about this before, usually you either file an answer and possibly counterclaims, or you can file a motion to dismiss or to strike like they're doing here before you get to answer, because you're saying, I don't even need to answer this because it's clear there's no valid claim. And so I'm not going to bother filing the answer until the court decides whether or not there is any merit to this. And so if this gets denied, the next step would be the parties would all file their answers. So that's the gist of it. Let me know what you think down below. I'd be interested to hear your opinions. I think it's pretty clear that this is frivolous and malicious. And in my opinion, this is an abuse of the legal process. But you let me know what you think. So I'd like to thank some people who sent stuff from the Amazon wishlist. Thank you so much for your generosity. And I wanted to preface this by saying there were a couple of items that arrived that we did not get gift slips with. So if you sent something, stop, Cedric. He's playing, but he gets a little too rough. If you send something and I don't thank you, please let me know. Send me a copy of the order or whatever, and I will take care of it. Cedric, stop. I would like to thank Kara N, who sent us 2 things of crunchy cat treats and a case of the Blue Buffalo wet cat food. Thank you so much. We go through so much food and treats in this house. Candace B, who sent us one of those nice elevated food bowl sets. Thank you so much, Candace. Really appreciate it. I would like to thank Rick S, who sent us 2 things of the Friskies pate cat food. Thank you for that. And Cedric is looking for a treat that is hidden half under my bladder here. And then from Brendan W, we got some Friskies pate cat food, some Cat's Pride litter, and a thing of cat treats. So Brendan, thank you so much for that. Hillary G, first she in her note, she recommends a couple of things to me for Stefan that it's easy for him to eat. So Hillary sent us, it looks like 2 things of jumbo cat treats and a 2-pack of the Friskies Party Mix treats, which the cats really love those. They like all the treats, but for some reason, those little Friskies ones they really like. So Hillary, thank you for your advice, and also thank you very much for the treats. And then from Diane Lee, we got a thing of Cat's Pride cat litter. Thank you so much, you guys. You guys, your generosity is just so unbelievable, and it always chokes me up when I see stuff on the porch from Amazon. and knowing that it's not something I ordered. So we really appreciate your generosity, and the cats really love the stuff. So thank you so much. I'd like to thank Adriana, who bought me 5 cups of coffee. Thank you so much, Adriana. I really appreciate it. And as always, I want to thank all of our Patreon patrons. We have some new ones again. Thank you so much, you guys. Thank you so much to our channel members. All of that monthly support that you guys pledge goes directly towards the vet bills that I pay every other week on Fridays. Like clockwork, my vet charges my debit card for their ongoing rolling balance that I have with him. And again, thank you so much to the people who donated for Stefan. I closed the fundraiser. We met our goal. Thank you so much. You guys went above and beyond. I really, really appreciate it. I will give you an update on Stefan's condition in the next video. I wanted to focus on, this is a fairly long video, and I wanted to really just focus on this. In the interim, take care of yourselves, love one another, and I will see you in the next one.
Pretty please. Subscribe, like, and hit the bell. I get a treat for every new sub. Thank you.